Obunkenke ku kooti y'amagye wano e Makindye, omukulu His Excellency Kyagulanyi Ssentamu Robert Bobwine olunaku olwaleero ate avuddeyo okulwanira mukwano gwe munywanyi we Dr. Komeera Kizza Besigye era nga alumbye kooti eno ng'abagamba nti omuntu waffe tulina okuddayo naye oba mwagala oba temwagala. Manyi bano bakatemba bo badde bagenda kulowooza nti bagenda kukola katemba nga babadde bamutambuza ebbanga lyonna naye leero Dr. Kizza Besigye alabika nga wakuva mu kkomera naye nga maanyi ga Kyagulanyi Ssentamu Robert Bobwine. Kyagulanyi Ssentamu Robert Bobwine nga tannaba kujja munnange bwe Dr. Kizza Besigye yakamala emyezi 2 mu galeetwa mu kooti wano naye nga tebamusalira musango. Naye leero Kyagulanyi Ssentamu Pulezidenti w'ekibuli ataddewo ekibuli era embeera erabika nga egenda kutereera ddala bulungi. So baganda bange, mikwano gyange, nze kyennyinza okugamba abantu bano abalowooza nti ndina eggwanga lyabwe, abalowooza nti bye balina sseboka ku ggwanga lino, nti ebintu byonna mujja bikola mujja sigala ku likodi, naye ate era kyetuyinza obbagamba nti temusobola kulemesa maanyi g'abantu. Amaanyi g'abantu ge gasalawo ate era gajja kusalawo ebbanga lyonna. Naye mulikola mutya, naye muliremerako mutya, newe mulikola mutya, twongera obbajjukiza n'okubategeeza nti Pulezidenti Kyagulanyi Ssentamu Robert twongera obbajjukiza n'okubategeeza nti ye Pulezidenti era yewe eggwanga lino. Ko buli kimu kikole Kyagulanyi waaba tewakitatambula.
To close the chapter of Kizza because he was convicted and sentenced. If you are not satisfied, you know what to do on that one. I think let us proceed. That's not the part of the lawyer. So should we adjourn up to his finishes his sentence?
It's the guidance we are seeking from Mr. Chairman. How do we deal with this?
About the convict, the one who is sentenced, who is serving the sentence.
But he still has instructions.
So which means all of you cannot proceed.
I think it is very important what the judge advocate is giving us advice to this court, and I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this court will be very important, and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are entitled to side with the judge advocate, or for good reason to differ with him, because we are objecting also based on law, so that you are given the correct procedure. What happened to Aaron Person happened, and he is going to take action accordingly. But if moving forward, the proper procedure is not applied, then we are at risk. That's what we are saying.
I think, sir, we need to move forward.
Mr. Chairman,
and to close the chapter. All matters have been
resolved. No, we are closing the chapter, but what I want to tell the defense attorneys is that just feel free, unless you conduct yourself in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are held responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Mr. Chairman, allow me the latitude, Mr. Chairman. On the issue,
the last one.
Yes, much obliged, Mr. Chairman. On the issue of changing the panel, Mr. Chairman, it has far-reaching consequences. For instance, when at the ruling which resulted in sentencing my land friend Lero Kizza was being read, reference was made to his earlier conduct in 2024. But Colonel Okalebo was not present in 2024. However, he participated in sentencing Lero Kizza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
It's okay. I think you need to give them the list, the other instrument of ours, so that they understand the composition of this code.
Whoever wants, we have our own registrar there, and they are also advocates. They are there, they are seated, don't just think they are clerks. The major and the one next, they are also advocates. They manage our registry, which is also under my office. So you can ask anything. If it is an instrument of appointment, they have it.
Go ahead, we'll go with the state.
Mr. Chairman, just the last one, the very last one.
Mr. Chairman, I beg, Mr. Chairman, for your indulgence, Mr. Chairman, I thank you. This is the very last one, Mr. Chairman, which you raised in your communication, Mr. Chairman. Mr. Chairman, if I may be permitted, Mr. Chairman, I beg for your
I think sir, two lawyers cannot speak at the same time.
I am seeking for the indulgence of the chairman.
But he has not allowed you.
It's a humble, I know, and
Now, because if you are to conduct ourselves like that, then we may not go anywhere.
because, Mr. Chairman, we are dealing with matters of life and
Since
death.
we started, you are talking. Now let's hear from these people also.
It all depends on the gravity of the matters you are dealing with. The sentence we are talking about here is dead.
Chairman,
The charges is dead.
I think, sir, I suggest you, Reno Council Kwabo, you should respect the chair and quote. Two lawyers cannot speak at the same time when you are all standing. It's very unethical.
They cannot say anything.
Councillor Raphael, proceed.
On the 7th of January, when this matter came before this court, I intimated to this court that we intend to amend the charge sheet. But because of some administrative matters, we could not proceed, which happened in court. So, Chairman and court members, we want to amend the charge sheet and we are amending this charge sheet pursuant to Regulation 66 of Uganda People's Defense Forces Rules of Procedure. It is premised on the need to ensure that justice is effectively administered by holding all parties accountable. So during the course of investigations, some facts revealed that there is a serving UPDF officer who is connected to the offense. So we intend to have the charge sheet amended by addition of that officer. And we also intend to amend the charge sheet by adding there another count of treachery. So those are the two amendments we are seeking to amend. The person who is introduced on the charge sheet is RO 12743, Captain Dennis Ora, a male adult Ugandan, a soldier of regular forces of Uganda People's Defense Forces. and is attached to Armored Brigade. So is RO 74-3, Captain Dennis Ola. Is an officer attached to Armored Brigade. And we are also adding there the count of treachery, which will be count 2, including the officer and the 2 accused persons. Those are the amendments we seek to have.
Mr. Chairman, we object to the amendment, especially before the ruling on jurisdiction. In fact, we stopped the application for reference to await the ruling on jurisdiction. We feel that amending to add a person who is serving in the military is meant to preempt the ruling on jurisdiction, because the court has no, it's in our view that the court has no jurisdiction on these 2 gentlemen, and we seek that the ruling precedes the amendment of the charges, when we then can raise full objection, because the charges, the amendment is not sought properly pursuant to the rules of procedure. Any colleague?
Council, which ruling are you talking about? Which ruling are you talking about?
On the ruling that you referred to Mr. Lukwago having argued on your jurisdiction to try these 2 gentlemen. There is a ruling you've been seeking to deliver ever since we came.
From the Supreme Court?
From yourselves, from this court martial.
That was read on the first day.
So there is a ruling which was delivered on the same day it took place.
But he's aware he was here.
Mr. Chairman, honorable members, we have been under the impression that there is a ruling, I think on several occasions, that was supposed to be delivered. And that ruling relates to matters that were raised the first time the accused persons were charged. That matter, I think, has something to do with jurisdiction. It has something to do with the extraterritoriality of some of the offences and how they got here, and therefore the price of the charges. So we have all along been under the impression that there is in fact a ruling. I do recall my land friend of mine once actually was and saying we are ready to proceed. But the events that have taken place since that time have not enabled that to happen. So we are keen on receiving the ruling. Mr. Chairman, that is point number 1. Point number 2, which relates to what my land friend has just prayed about, the amendment of charges. I am looking at the rule that he has cited on amendment. And it talks about amending charges where there is a mistake in the name or description of the accused, or a mistake which is attributable to a clerical error or omission. And he did say that in the charge there had been reference to a serving officer. I haven't seen that reference myself in the charge, but I don't think that calling somebody a serving officer is a clerical error or omission, so that now we have found the name. We must have known the name, but just refused to put it there. So I'm not sure that that regulation 66 allows him to do what he's asking to be done, to join I have even lost the name, Captain Dennis. So I just rise on those two issues, Mr. Chairman, the ruling and then prior to what my landlord is asking.
Mr. Chairman, for the record, Omulamuzi Atidde, I associate myself with the submissions of my senior land friends. Mr. Chairman, the move by the prosecution is a calculated way of defeating the defense which has already been brought to your attention through preliminary objections raised by my senior land friend, Counsel Elias Lukwabo, when he objected the jurisdiction of this court. And indeed, there is a pending ruling. The other time when Senior Counsel Martha Karua came, we were not allowed to proceed with receiving that ruling, awaiting the grant of a temporary practicing certificate to Senior Counsel. Indeed, Mr. Chairman, there is a ruling pending before this court, and the prosecution is trying to, yes, if the prosecution refers to the notes they've been taking, they realize that indeed when we compare the same with ours, there is a pending ruling, and they intend to preempt the ruling, Mr. Chairman. Don't allow them, they will be defeating this. Mr. Chair, just for recollection, it may be recalled when a senior colleague, Mr. Karua, in the last hearing raised an application for an adjournment for an hour, and court wasn't willing. Court graciously granted us 15 minutes. At that time, the business of the court before the adjournment was to deliver a ruling regarding matters raised by Mr. Elias Lukwabo. That was overtaken by events because when we came back in the afternoon, we did indicate to court that there were issues regarding instructions to receive the ruling and also the matter of Mr. Lero Kizza. So it is correct, if I recall, that it was at my request that we were granted an adjournment of 15 minutes so that we'd come back and the issue of the ruling was still in the House. Perhaps, Mr. Chairman, it may be necessary for court to retreat for 10 minutes just to confirm, but it is correct that there was a pending ruling regarding those issues raised by Mr. Thank you, Mr.
Chairman and court members. Counsel Ernest Karibara read the regulation 66(1), but did not proceed to paragraph 2, which states that if at any time during the hearing at which there is a judge advocate, it appears to the court before it closes to deliberate on its finding that it is desirable in the interest of justice to make any addition, omission, I can't even stop it. So that is the additional. I'm moving upon that paragraph. So on addition by adding there, because this is
they cannot amend at this stage. I want to ask the prosecutor needs for the area matter.
The court is adjourned for 10 minutes.